Good afternoon, and thank you for attending today's webinar, What's New in the Employee Benefits World in 2018. Before we begin, I'd like to introduce today's presenters. We have Nancy Keppelman and Lynn McGuire from Butzel Long. Nancy Keppelman is of counsel and is based out of Butzel Long's Ann Arbor office. Lynn McGuire is a shareholder and is also based out of Butzel Long's Ann Arbor office. Both specialize and concentrate their practice in employee benefits and executive compensation law. Before we begin the presentation, I'd like to take care of some housekeeping. If you have any questions during the presentation, please feel free to submit them using the question panel on GoToWebinar. Directions to do so are here on the screen. Time permitting, the presenters will try to answer your questions at the end of the program. If we run out of time, the presenters will be sure to reach out to you individually after the presentation to answer your questions. Additionally, a copy of this presentation will be available to download on this event's webpage on Butzel.com. Simply go to Butzel.com/events, find this webinar event, and click, and you should be able to find a link to download the presentation. If you have any difficulties, please send me an email at spencer@butzel.com. That's SPENCER @butzel.com to download a copy. So with that, I'd like to hand the webinar over to our presenters, starting with Nancy Keppelman. Nancy?
Thank you, and thank you for joining us today. Today we're going to review the employee benefits changes adopted as part of the Tax Cuts and Jobs Act at the end of 2017 and the budget agreement in January 2018, as well as Treasury Department changes to the IRS determination letter program. I'm going to cover the participant loan changes and hardship distribution changes, and Lynn is going to cover a brief summary of the executive compensation changes and some other changes that deal with miscellaneous welfare issues, as well as the IRS determination letter program changes. Before we start, I'd like to just do an overview on loans and hardship distributions. I'm sure you are all aware that the 401k rules prohibit the distribution of employee elective deferrals before the employee terminates employment, reaches age 59 and a half, dies, or becomes disabled. The loans and hardship distribution provisions are exceptions to those distribution rules. Both loans and hardship distributions are discretionary provisions. You can offer loans or hardship distributions, or both, or neither of them. As a quick overview, loans allow an employee to get a temporary withdrawal of elective deferrals. If the loan meets the requirements for the term for the loan and the repayments and the limit on the amount when it is taken out, then it is the money that's paid out to the participant is not taxed. The loan has to be repaid in accordance with its terms, and if it is not repaid, the unpaid balance becomes a taxable distribution. Hardship distributions, on the other hand, are a permanent distribution of elective deferrals in the event of a hardship. The distribution must meet certain restrictions on the reason for the hardship and on the amount. A hardship distribution is taxable when it's made and is subject to 10% penalty if paid before the participant reaches age 59 and a half. Hardship distributions are not repaid. With that overview to remind us of why we have loans and hardship distributions, let's go on to a description of current law and what's changed. First of all, we have a cartoon that the loan officer asks the prospective borrower, do you have any other collateral besides this email from a Nigerian prince? Well, of course, in our 401k plans, the collateral is the account balance itself. As background for the reason for participant loans, Employers tend to allow participants to borrow from their account as a way of giving participants access to their own money before they terminate employment. This encourages participants to make contributions to the plans because they know that they can access the money if it's really needed. Most loans are paid by payroll deductions, and when employment terminates, those payroll deduction amounts end. And at that point, most plans provide for the loan to be in default. Once a loan is in default, it triggers taxation of the entire outstanding loan balance, and often if the participant is under 59 and a half, there's the 10% early distribution penalty as well. So it is a difficult problem for a participant with a participant loan when he or she terminates employment. As a note, you can amend your plan to allow loan repayments to be made after termination of employment. There's no legal requirement that the plan cut off loan repayments at termination of employment. In addition, a plan or the plan's loan policy, if it's separate from the plan, can be amended to permit rollover of participant loans after termination of employment if that rollover is accepted by another qualified plan. That sort of rollover would avoid the tax consequence of the loan default. When the loan is defaulted on termination of employment, or if the participant just doesn't repay the loan as required, the loan offset amount is treated as a distribution. For example, if a participant has a $1,000 outstanding loan balance when they terminate employment, the plan will treat that $1,000 as a taxable distribution unless the employee repays the loan before the rest of his account is distributed, or the amount is rolled over in some way. Under old law, participants have 60 days from the date the loan offset occurs to roll over the outstanding loan balance to an IRA or a qualified plan. In my example, that means a participant's got to raise $1,000 within 60 days and deposit that $1,000 in the IRA or qualified plan where the rest of his or her account was deposited in a rollover. That's a pretty short time when the loan balance is substantial. Under the new provision, any loan amounts that are treated as distributed after 2017 have an extended rollover period. The participant can now roll over the outstanding balance of the loan by the time for filing his or her tax return for the year in which the rest of the account was distributed, and that includes extensions of the tax return filing date. For example, if someone took a loan distribution on June 26, 2018, he or she would have until April 15 of 2019 to come up with the outstanding balance of the loan and deposit it in the IRA or new qualified plan and avoid taxation. And if that person extended the April 15, 2019 due date, they'd have even more time. Note that you cannot roll over any part of a loan which was already treated as a distribution, and also a loan itself can't be rolled over to the IRA. However, one of the advantages of this extended loan payment extension is that you could deposit the funds in the IRA rather than having to try to roll over the loan to somewhere else. Well, so now that we know this new rule for the extended time to repay the loan after termination of employment or to roll over the outstanding balance, what should you do as a plan sponsor? One of the things you should do is revise the special tax notice which you give to participants when they terminate employment and receive a distribution from the 401k. You'll recall that this notice advises employees of the tax consequences of getting a distribution from a plan and of their ability to roll over to a new qualified retirement plan or IRA. You should amend that notice to tell participants they have this extended deadline for paying the outstanding loan balance into the new retirement plan or IRA. We hope the IRS will issue a new special tax notice which includes this. The IRS has provided us with the text of these notices in the past, but we're not sure when they might get around to doing that. A couple of other things you could consider doing. You could amend your plan to allow rollovers of loans to another qualified retirement plan so that the participant doesn't have to come up with the outstanding loan balance. Or you can allow repayments of the loan after termination of employment if you wish to do either of those things. But if you consider those things, please check with your third-party administrator to make sure they can accept post-termination loan payments. There can be some tricky issues there if participants are sending checks in, for example. Another question you might consider is, should your plan accept loan rollovers from some other plan? If you have a new employee who comes to you and says, I want to roll over my 401k account from my prior employer and I have an outstanding loan balance and I'd rather not pay that off, can I roll over the loan to your plan? You might want to consider allowing that, although that involves some tricky administrative issues because you have to get a copy of the prior loan and make sure payments are made in a proper time. All right, that's the helpful news for participant loans. Let's turn to hardship distributions. And here we have a fellow who's consulting with his financial advisor who tells him, I reviewed your investments and set you up for early retirement. On your last day of work, you can afford to leave at 4:30 instead of 5 o'clock. I think we may all have some sympathy with that issue. And of course, if participants take hardship distributions from the plan, they will have less retirement assets with which to retire earlier. But we do have some helpful things to deal with hardship distributions from these new tax changes. The tax code allows qualified retirement plans to allow in-service distributions from the participant's account balance in the event of certain hardships. But in those cases where there's been a hardship distribution, the plan has to stop the participant's elective deferrals for 6 months following the hardship distribution. In addition, we have two conditions that relate to hardship distributions. One of those is the reason for the distribution. It must be made on account of an immediate and heavy financial need of the employee, and those are the words of the rules. And in addition, the amount that the hardship distribution is for must be necessary to satisfy that financial need and not be more than that. I note that amounts that are attributable to employer matching and discretionary contributions aren't subject to these restrictive hardship rules, so a plan could allow hardship distributions from matching or discretionary or profit-sharing contributions that don't have to follow all of these restrictions that apply to the participant's salary reduction contributions. But if you do that, then you've got two sets of hardship distribution rules, and that can be difficult to administer. I don't know of very many employers who opt to have two different sets of hardship distribution rules. As is true for almost everything that we do with qualified retirement plans, the hardship distributions, and of course the loans as well, must be made in non-discriminatory and objective standards that are set forth in the plan. So you want to make sure that you aren't tailoring your loan rules or your hardship distribution rules to benefit just your highly compensated employees. All right, well, the IRS says we've got to meet both the reason for the hardship distribution and the amount, and they've given us safe harbors for determining whether we meet its requirements. The hardship distribution is deemed to be on account of an immediate and heavy financial need if it's for one of the following types of expenses. Expenses for medical care for the employee, the employee's spouse, or any dependents of the employee, the costs for the purchase of a principal residence for the employee, but not just to pay the mortgage, for tuition, educational fees, room and board expenses, and so on for the next 1 year, 12 months of post-secondary education for the employee, the employee's spouse, children, or dependent. Payments necessary to prevent the eviction from the employee's principal residence, which would typically be in the case of a rental, or to prevent foreclosure on a mortgage. Funeral expenses for the employee's deceased parent, spouse, children, or dependents. Or the last item is repairs to the employee's principal residence that would qualify for the casualty deduction. And we'll get to a glitch on casualty deduction expenses a little bit later. The second requirement, as we've mentioned, is that the hardship distribution can't exceed the amount that the employee needs to actually pay for that hardship expense, and it can't be something that the employee could satisfy from other resources that are reasonably available to the employee. We have a safe harbor for this amount restriction on hardship distributions. The amount can't exceed the amount of that immediate and heavy financial need, but that can include income taxes and the 10% penalty that would result if the distribution is made to a participant who's under 59 and a half. The second part of the amount restriction is that the employee has to obtain all distributions other than another hardship distribution and all non-taxable loans currently available under the plans maintained by the employer. We'll get back to that non-taxable loans requirement a little bit later because that's been changed. I note that if the plan does not allow loans, then obviously the employee doesn't have to try to take out a loan. So, what are the new laws that apply to hardship distributions? Well, there's one provision that doesn't exactly deal with either the reason for the hardship or the amount, and that is Congress can waive the 10% early distribution penalty for hardship distributions that are made by reason of qualified hurricane or disasters, as long as those are repaid within a limited time frame. The IRS can also allow hardship distributions to those who are affected by storms and other disasters, and they can allow a window to amend the plan to allow hardship distributions provisions consistent with this relief. Now the problem is that this is new enough and the IRS hasn't yet issued any guidance about when we must amend plans to add new hardship distributions or other rules dealing with distributions affected by storms and other disasters. So we have the possibility that we could have this relief from the 10% early distribution penalty, but we're not quite sure what the rules are that govern that relief. Now, on something that relates to this distributions by reason of some storm or hurricane or similar disaster, because the Tax Act changed the definition of what constitutes a deductible casualty expense, we have a difficulty that relates to hardship distribution safe harbors. The statute was amended to limit deductions for casualty expenses to those that are tied to a presidential declared natural disaster. So that means that the casualty reason for a hardship distribution is, unless somebody does something to help us, limited to casualties arising out of a disaster that is presidentially declared as a natural disaster. We're hoping the IRS will change the hardship safe harbor to broaden the definition of casualty so that it will cover disasters or casualties that aren't part of a presidentially declared natural disaster. And this could include something like a fire in an individual's home or a localized storm that is heavy and causes damage but doesn't rise to the level of a presidential declaration. However, we don't have any of that guidance yet. So here we have a poor fellow who is trying to figure out whether the flood that has inundated his home is going to allow him to take a hardship distribution for repairs to the home. The second area of hardship distributions where we have less restrictive rules is that there are certain limitations before now, or actually this year as well, on what money can be paid out in a hardship distribution. Right now, all you can pay out in a hardship distribution is the employee's elective contributions, no earnings, and no qualified non-elective contributions or qualified matching contributions, which may have been made to a participant's account in order to correct a violation of the non-discrimination testing rules for employee salary reduction contributions or the match. Starting next year, amounts attributable to these QNECs and QMACs can also be distributed in a hardship distribution. This is particularly helpful in terms of plan administration. It's not clear whether all plan administrators separately account for QNECs and QMACs. Sometimes they just put them in the 401k account. So this will be helpful in administering hardships and the amount that can be distributed. Another new provision that's very helpful is under current law, participants must suspend their elective deferrals for 6 months after they take a hardship distribution. Starting next year, the plan no longer has to stop participant elective deferrals for that 6-month period. And in addition, participants are no longer required to take out a plan loan, if the plan has loans, before taking a hardship distribution. The IRS has been directed to issue new rules within a year of the enactment of the budget bill, which was back in January, to deal with these two changes. Of course, they haven't issued these yet, and they may or may not make the 1-year requirement, but hopefully we'll get guidance sometime in the near future. All right, what do you need to do as a plan sponsor in order to react or implement these hardship distribution changes? First, if you want to implement the disaster relief hardship provisions, you'll need to amend your plan document to provide for those things. Also, if you want to stop suspending participant contributions for 6 months after a hardship distribution, that will be a plan amendment. And in addition, you need to amend your record-keeping or third-party administrative services agreement to accommodate these changes. And I strongly suggest that before you make changes to either the loans or the hardship distributions, that you have discussions with your third-party administrator about changing these rules, what your administrator is prepared to do at this time, or they might be prepared to do in the future, and basically make sure that your plan document or your loan agreement policy is the same as what your plan administrator is doing. One of the things that we see in our practice are situations in which the plan was administered in a way that doesn't match up with the plan document. And that's something that you should make sure your plan administrator can accommodate your changes to your document. Also, if you decide to eliminate the 6-month delay and you are resuming elective deferrals, this could be an issue with auto-enrollment plans. Would elective deferrals resume at the rate in effect before the suspension or at an auto-increased rate? And of course, if you don't have a suspension, then you need to decide, will the auto-enrollment level continue? For example, if you have a participant enrolled at 3% of pay and there's no suspension, you'll just continue to defer at the 3% of pay rate after the hardship distribution. That may require a bit of tweaking to your payroll requirements. Also, can your third-party administrator administer the resumption of participant elective deferrals without a new participant election? So those are two things that you need to consider that deal with the suspension of benefits after a hardship distribution where you have an auto-enrollment plan. With that, I'm going to turn everything over to Lynn to continue with the discussion of executive compensation and our other items of welfare plan changes.
Thank you, Nancy. There were a surprisingly large number of miscellaneous benefit provisions that were changed in the budget and tax cut acts. And the federal government's also been busy behind the scenes making administrative changes in other areas as well. So I'm going to go through a variety of these items. The first one I'm going to talk about is executive compensation. This is an area that doesn't impact every employer. It's an area that doesn't really affect all employers in the same way because there are so many different types of executive compensation programs. So because of that, I'm not going to go into the details on this. I'm simply going to give you an overview, kind of a warning list here. If you are a company providing over $1 million a year in compensation to some of your employees, you should talk with your legal counsel. There are changes that may affect you. If you are paying employees under a performance-based compensation system, so for example, if you've got an executive compensation agreement with your CEO that says if you're able to meet certain performance-based standards like company earnings or sales, those types of metrics are now being subjected to new rules under these laws. So talk with your legal counsel. You may need to make changes to your existing agreements. If you're a nonprofit employer and you provide severance payments equal to $1 million or more to any individual, you also need to speak with your legal counsel because there are changes in the way those will be taxed. Severance payments also include provisions, even if they're not in a severance plan. If you've got a provision in your employment agreement and the payment is triggered when somebody terminates employment, that's considered severance as well. So that falls in the same category. Check with your legal counsel. The last category is stock options and restricted stock awards. There have been changes in those areas. You may need to make changes to your existing plan documents. So the rest of the provisions I'm going to talk about come in to touch upon a variety of different types of employee benefits. I thought this was an appropriate cartoon to kind of talk about that variety. The doctor's saying, it's a pacemaker for your heart. Plus, you can download apps for your liver, kidneys, lungs, and pancreas. So on that note, let's dive into the first category. This is for employers that are subject to the Family and Medical Leave Act. Now currently, under current law, employers that are providing paid Family and Medical Leave Act leave can take a deduction under certain circumstances for that wage payment, the wage replacement payment. Not every employer is able to take a deduction, however, so they've added this new tax credit to the law to help those employers that might be better off with this credit rather than under the existing deduction scheme. The new credit, the new tax credit, ranges in dollar amount or percentage amounts between 12.5% and 25% of the wages that the employer pays to this employee as replacement FMLA pay. And it only applies in 2018 and 2019. For budget purposes, it ends after that. So in order to qualify for this new tax credit, the employer has to provide at least 2 weeks of that annual paid FMLA leave. And the level of pay has to be at least 50% replacement of the current existing salary for the individual. It also has to be provided through a written policy, so they are not going to allow you to provide on an ad hoc basis wage replacement to some individuals who get FMLA and not others. It's got to be a uniform written policy. Now, the employee also must be employed by that employer at least 1 year in order to take the credit for the FMLA wage replacement amounts. And this may sound a little odd, but I think the idea here was that Congress wanted to make sure that employers weren't just shifting normal pay into the category of FMLA leave replacement, normal sick leave type pay. So they wanted to make sure that this was something separate and different from what you give every employee. The individual also can't have prior year compensation in excess of 60% of what a highly compensated employee limit is for the year. And for 2018, the limit is $120,000. So the goal is you can take a tax credit, but if somebody's too highly paid and you're giving them too much money, you don't get the credit. But you do for basic rank and file people. They also want to make it clear that you can't take a credit for plain old vacation pay or personal leave pay or any other type of medical or sick leave pay that you're providing employees. This really has to be true FMLA paid leave replacement. And there are a number of states and local governments that have a mandated paid leave program in effect. You also can't take a federal tax credit for those payments either. Now I'm going to talk about the tax cut provisions. I thought this was an appropriate cartoon for that. This is a politician saying, if elected, I will lower my taxes. Hey, it's a start. So you're all aware at this point, I'm sure, that the new lower tax rates have gone into effect already in 2018. The withholding rates are lower and the tax rate at the end of the year is lower. But you may not have thought about what effect that might have on your employee benefit programs that you offer. Well, one effect is that with these new lower tax rates, that makes a Roth contribution more favorable relatively. And with a Roth contribution, an individual gets to put money into their retirement plan. They do it on an after-tax basis, but the money that goes in and the earnings on that money come out of the plan without paying taxes. So if you're in a lower tax bracket now, that makes this a relatively more favorable benefit. So if at some point in time you made a decision about whether to offer Roth contributions within your 401k plan or not, it may be time to revisit that decision. Or if at some point in time in the past you told employees that they should perform a calculation to figure out whether Roth contributions were more favorable for them or not, and you provided some kind of a Roth calculator, it may be time to reintroduce that and ask people to do the test again to see whether now, with the lower tax rates, they might come out ahead when they didn't before. This is also a benefit for individuals who are owners of an S corporation or a partnership or an LLC that's chosen to remain taxed as a partnership rather than a corporation. So you get this extra benefit from those Roth contributions. If you're an owner of one of those entities, you also get to deduct those contributions. So not only do they get the Roth benefit, but they get an extra corporate deduction, or not corporate, but a company deduction. And the next provision I'm going to talk about operates in the opposite direction. It's not an advantage to individuals. This is a takeaway. And this was part of the idea of getting the budget balanced and reducing federal costs. So employer-paid moving expenses used to be deductible by the corporation, and they wouldn't be included in the individual employee's taxable income. It was a tax-preferred benefit. Under the new law, that's no longer true. You have to treat it as taxable compensation to the employee. Now, over the past few years, employers have been very actively recruiting employees and trying to ensure they can retain employees. So moving expenses are something that the employers have increasingly looked to as a way to attract employees who are qualified. You may not want to have this tax provision change your strategies. You still want to attract employees, but just keep in mind that you're going to have to change your payroll system to record the fact that those moving expenses are now taxable to the employee. Additionally, you might want to think about whether this new form of taxable W-2 income that the employee is going to receive is something you want to carve out from the definition of compensation that you use in your retirement plan for purposes of calculating either employer contributions or the individual's ability to make an elective contribution. So this is something that's going to show up on the W-2 as taxable income. If you want to make a change to your retirement plan, you'd have to affirmatively amend the plan. But keep in mind that you may not want to tinker with your definition of compensation in every instance in your retirement plan. There's some retirement plan designs where you would not want to make that change. Definitely speak with an ERISA attorney before making any change. Another takeaway is that currently qualified transportation benefits and bicycle commuting expenses are deductible by the employer. The employer provides these benefits to the employee, and the employee doesn't have to have them treated as taxable income. Under the new tax law provisions, that goes away. The employer provided transportation benefits, and this is things like bus passes and parking costs, as well as the bicycle commuting expenses through a bicycle commuting program. Those are no longer deductible by the employer, but there's still going to be exempt benefits for the employee. So there's still some advantage to the individual, but not the company. There's an interesting twist here for nonprofit employers. Because nonprofit employers generally are not concerned about deductions, the twist for them is that these costs are actually going to be treated as unrelated business taxable income. It's kind of a perverse thing that they're now going to have to file a new type of tax form just because they're providing this extra benefit to employees. Now, the next area I want to talk about is the Affordable Care Act. I think you've probably heard about the Affordable Care Act before now. The individual mandate under the Affordable Care Act was the provision that says individuals have to have group health coverage, and if they don't, they're going to be taxed, basically. There's a penalty that results. And the penalty escalates over time, getting bigger and bigger to the point where it makes sense for employees financially, individuals financially, to elect coverage rather than putting up with the penalties. As of now, under the new provisions, starting in 2019, that individual mandate is being reduced to 0. So for employee benefits, what does that mean for you as an employer offering group health coverage? Well, one thing that means is that you may have employees who choose to go without your group health coverage. They don't want it or don't need it. And if you want to avoid the cost of the employer subsidy for your group health coverage, you may want to think about adding in to your cafeteria plan an opt-out cash benefit that basically says, I'll give you X dollar amount through the cafeteria plan if you agree to forego the group health coverage. And you structure the dollar amounts so it's a win-win. It costs you less than the subsidy, and it gives them a little cash that they can use for other purposes. Now, one thing to be forewarned on is that some states are now adopting state-level individual mandate penalties. So far, New Jersey and Vermont are the only states that have adopted the penalties. But essentially, they're saying we've got requirements here, and we're going to tax individuals that live in our state if they don't have health coverage. And we expect other states may hop on board to this as well in the future. Currently, we know Washington State is talking about it, and others may be in line. The next provision I'm going to talk about affects employers that offer incentives, and specifically these are length of service awards and achievement awards. Under the tax code, those categories of employer awards have been treated differently in the past. Well, under the new provisions, if you provide a length of service award or an employee achievement award in the form of cash or gift coupons or general gift certificates, vacations, meals, lodging, tickets to sporting or theater events, securities, or any similar type items, you can't take a deduction for those anymore. And it's going to be treated as taxable income to your employee. So if you can imagine you're giving meals to your employee or you're giving a vacation, even though you haven't given them cash on their check, you will be taking cash out of their check to withhold for the taxes that result for the value of that benefit. So even though you're trying to incentivize and reward people, this can backfire on you. So now would be the time to rethink the types of awards that you're giving to your employees as incentives or length of service awards. There are still other categories that are permissible. Notice that it says general gift certificates. If you gave a specific gift certificate, for example, saying here's a gift certificate for a turkey from Joe's grocery store, that would still be a deductible and excludable benefit under an award program. But if it was a general gift certificate saying here's $100, go spend it at the grocery store any way you want to, that's taxable. There is one peculiarity in this law, and that's that there's a carve-out expressly for those companies that provide motivational award booklets. They're set up so that employees earn a certain number of points when they do things, and then they get to add up those points and turn to any page in a booklet and pick out any item from that booklet as their reward. Because they've got the ability to choose what they get, and it's not just a specific cash amount, those are carved out from this new rule. So those are still deductible and still excludable from compensation. Now I'm going to turn back to the qualified retirement plan world again. You may be aware that the IRS previously cut back severely on its determination letter program for individually designed qualified retirement plans. Now what this was essentially a program through which you would submit the plan document for your individually designed retirement plan to the IRS. The IRS would review it and determine whether or not your language was adequate to meet the tax exemption requirements, the tax preferred requirements. And if it met the requirements, they give you a determination letter that you could use to show other people who are interested that your tax qualified status is in place. And then every 5 years you could apply again so that subsequent amendments could get a determination letter as well. Well, the IRS has eliminated that program for the most part. It's only available right now for a brand new plan, or when you have a plan termination, or in some other unique situations. It's not just generally available across the board. They have retained and slightly expanded the program that's used by the IRS to give opinion letters for a pre-approved retirement plan. And currently those come in the form of volume submitter plan or a prototype plan. Those two categories are going to be merged by the IRS going forward, so that there's just one document category rather than two. But generally, the IRS has cut back greatly on these programs. Well, the IRS is now considering whether to expand that determination letter program again to cover specific situations other than just a new plan adoption or a plan termination or the off-plan situation that we talked about. We don't believe they're going to go whole hog and reinstate the program, but at this point it's likely that they may add in a couple of unique situations where they will issue a determination letter. That really doesn't help employers that don't have one of those unique situations. So what do you do if you want to show that your plan continues to be qualified tax exempt? Well, one thing you can do is to obtain an opinion letter from your legal counsel. The way that works is you provide the plan document and all subsequent amendments to your attorney, and the ERISA attorney reads through the tax code provisions of the required changes that have to be put into your plan and checks to make sure that they were put in properly, then issues an opinion letter that you can use for outside purposes to show that your plan, in legal counsel's opinion, continues to be tax qualified. And this comes in really handy in situations like a corporate acquisition or spin-off, where you're trying to represent to the other side that this plan is qualified and we haven't done anything that would blow up your tax qualified status. It's also becoming more common now in audits as we move out in years along the timeline from the date of the last valid determination letter issuance. Auditors are now looking for other ways to ensure that you haven't adopted amendments that would render your plan disqualified from a tax standpoint. So if either of those are of interest to you, you can seek an opinion letter from your legal counsel.
Okay. Well, with that, I want to thank you, Nancy and Lynn, for the excellent presentation. And I also wanted to thank everyone who took time today to attend this webinar. Please feel free, if you have any additional questions for the presenters, to contact them. Their contact information is there on the screen. Additionally, a reminder that a copy of the presentation can be found on butzel.com/events. If you just navigate to this webinar's event page, there'll be a link to download a PDF copy of the presentation. Thank you again, everyone who attended, and have a great afternoon.